Hello friends, welcome to learning sessions and good evening to all of you. And today in this video, we are going to discuss about the letter of credit. So previously we were also covering about the letter of credit and today we are going to discuss the complete details about it. So do confirm the audio to quality at the earliest so that we can proceed. And make sure to subscribe the channel if you have not subscribed the channel so far so that uh, you can be going through all the videos for the bank financial management and the CAIIB exam. The complete course is available. You simply need to download the application from the above link, that is iibf.info/app, or you can simply be WhatsApping us on the number 83609 So just WhatsApp on this particular number writing CAIIB and I'll be sending you all the details related to it. So we have covered the 39 different articles for the letter of credit under the UCPDC, that is a Uniform Customs and Practices for the documentary credit. We covered the particular uh, articles, and now we are going to cover about the E rules and the EUCP, about the URR 725, about the Incoterms. Again, very much important. So make sure to watch this video till end. And in the end of this video, we'll also be covering the case studies for the letter of credit. So EUCP or the E rules is basically the electronic rules we are talking about. So EUCP is electronic uniform customs and practices for the documentary credit. And these are basically supplement for the electronic presentation. So if the letter of credit documents are presented electronically under the UCP 600, so it supplements the particular criteria related to it. So these were first issued in the 2002 and further those were revised in 2007, and for the current version which is going on, which is effective from the 2019, is a version 2. So version 2 is right now applicable, and further it's related to the advanced, that's basically covers a digital letter of credit, right? And the E rules basically will continually monitor and update it so as to reflect the technological development if there is any. And further, ICC is going to ensure that E rules applicable to the banks and the other trade financial institutions. And if we talk about the E rules particularly, so we are having the key provisions under the E rules that's basically ranging from E1 to E12. So these are the different rules under the EUCP 2.0, right? Like under the E1, the scope is given, E2, the definitions are given related to electronic record. Now, what do you mean by electronic record? So if you're talking about electronic record or electronic UCP, then what do you mean by electronic record? So it's about the data which is created, which is sent, received electronically. That is the electronic record. That is the electronic record. And for the digital signatures are used so as to authenticate. So those are said to be the electronic signature. Those are said to be the electronic signature, right? And further the E3 describes about the format, and further the presentation, examination, all the rules related to the electronic UCP are given under it. These are given under it. So basically it facilitates paperless trade, it reduces the courier cost and delay, and further it integrates with the Swift and the trade portals. So that's about it. So that is about it. Clear with it? Further after that, it's related to the URR 725. URR 725. These are the uniform rules for bank-to-bank reimbursement. URR 725. Now, specifically, sometimes a reimbursement bank is basically there that's going to reimburse to the negotiating bank. That's going to reimburse the negotiating bank. Like I told you, the working is like there is a main contract between the importer and exporter. Importer went to the bank and for the bank checked the particular credit worthiness and opened the letter of credit favoring the beneficiary, that is the exporter, and further advised the letter of credit through the advising bank to the exporter. Exporter looked into the documents and further made the shipment and presented the documents to the nominated bank, that's a negotiating bank. Negotiating bank either will be making the payment on demand, or further it may be possible that the negotiating bank must have basically made the payment based upon the usage terms, right? Now, once the payment is made, it's a duty of the issuing bank or opening bank so as to pay the compensation, to pay the amount in the nostro account of the negotiating bank. That is basically the duty. Now for this particular case, it may be the case that a separate bank is there, that is said to be the reimbursing bank, who is going to reimburse the negotiating bank. And for that particular scenario, the rules of URR 725, that is Uniform Rules for Bank to Bank Reimbursement, would be applicable. Clear with it? Do confirm at the earliest. So that's the whole process related to it. So URR 725 is related to what? These are the uniform rules for bank to bank reimbursement and the documentary credits under the publication number 725, and it's approved by the ICC, International Chamber of Commerce, national committees at the Banking Commission in April 2008. And further, it is effective from October 2008 only, and it's the updated version. Previously the version was URR 525, but now the version which is used, it is URR 725. So whatsoever the reimbursements are going to be there, which are going from bank to bank purposes, those will be dealt with it. Those will be dealt with it. And specifically, it is to be expressed. It should be expressively be indicated on the credit. Only then these rules will be applicable. Like it will be mentioned on the letter of credit that the URR 725 rules will be applicable. Only then it will be applied, otherwise not. And further, once it is mentioned, it will be binding on all the reflected parties. All the reflected parties. Now let's have a look at the definitions under the URR 725. First one, it's related to the reimbursing bank. So reimbursing bank is basically that bank which is appointed by the opening bank or by the issuing bank, which is basically instructed or basically which is authorized so as to reimburse the nominated bank. So as to reimburse the nominated bank, that's the reimbursing bank. And what is reimbursement authorization? So it's an authorization which is given by the opening bank while opening the letter of credit. So it's an instruction, it's a authorization. And further, this is independent of the credit. It has nothing to do with the letter of credit as such. It's basically an authorization which is given by the issuing bank so as to reimburse the bank, so as to reimburse the claiming bank particularly. So if it is requested by the issuing bank and accepted by the reimbursement bank, so it will be an obligation. It will be an obligation on the reimbursement bank so as to pay the claiming bank when the particular situation will met up. So there is an reimbursement undertaking which is given by the reimbursement bank, and it will be an irrevocable undertaking. Irrevocable undertaking means it cannot be cancelled. So it will be the case like issuing bank is going to instruct or going to authorize the bank R, let's say, right, that you are to reimburse the claiming bank when this particular situation will meet up. Right. So it's an authorization which is given, and further a irrevocable undertaking will be given by the reimbursing bank to the issuing bank that I'll be making the payment to that particular bank if the particular situation is met. I'm going to honor the situation, and further it's a separate agreement, we can say, and separate from the letter of credit it is. And claiming bank in the last would be that particular bank to whom the particular reimbursement is to be made, right? So the bank basically who is going to honor the letter of credit, who is going to negotiate the credit, and further that's going to present a reimbursement claim to the reimbursing bank, and the claiming bank basically is authorized so as to present the reimbursement claim. And if it's a valid claim or it's a complying claim, then the reimbursing bank is obligated so as to pay off the reimbursement. Clear with it? So reimbursement bank will be having maximum 3 banking days following the day of reimbursement claim. So let's say reimbursement claim is basically given on the day 4th. So the another 3 days now will be available, like 5th day, 6th day, and 7th. So 3 days will now be available following the day when the claim was basically presented by the claiming bank to the reimbursement bank. The 3 banking days, not the calendar days. These are the banking days which will be available, and reimbursement claim received outside the banking hours will deem to be received the next working day. Clear with it? Do confirm at the list. After that, we are going to learn about the Incoterms. Incoterms, very much important. I told you about two Incoterms in very short, about the CIF value and the CFT value. We discussed about that. About the CIF value, I told you. About the other terms I told you, like, right? So FOB value and CIF value I have already told you that FOB is free on board and CIF is cost, insurance and freight. So what are these Incoterms? These are international commercial terms. These are international commercial terms. And further, this is basically related to the international language, we can say, so that nothing is basically misinterpreted. So these are the standardized trade terms which are used. These are the standardized trade terms which are used so that nothing is misinterpreted. And further, these are issued by ICC. ICC issues the Incoterms. Okay. And further, they do not govern the transfer of ownership. They do not govern the payment terms. They do not govern the breach of contract. They do not govern the dispute resolution. What they define is they define the delivery point. They define the transfer of risk. They define the allocation of costs. And they define the export import clearance responsibility. That's it. So what things are defined by them? Let me write over here. So what things are defined by the Incoterms? Like they do define the delivery point where the goods will be delivered. So delivery point is defined by them. And other than that, it's the transfer of risk. It's the transfer of risk which is defined. Further, it's the allocation of costs. Allocation of cost, how the costs are allocated, and also the clearance responsibility, export or import clearance responsibility. These are defined by the Incoterms. Clear? And further, as of the current version, we are having total 11 rules. We are having the total 11 rules about it. What are those total 11 rules? Let me just tell you one by one. The first one, it's about the EXW. The first one is it's the EXW, that seller is going to deliver at on premises. X works means where the work is going on, where the goods are being manufactured. The seller is going to deliver on only there, right? And buyer is going to bear all the cost risk from the seller's gate. So here's the factory. So seller is going to deliver here only, and rest all the responsibility, all the costs, all the risks are with the buyer. And seller is not responsible for the export clearance. Seller is also not responsible for the export clearance, and maximum obligation is on whom? It's on the buyer. The second one, it's about the DAP. The second one, it is about the DAP, that is delivery at place. So seller is going to deliver, seller delivers ready for unloading. Seller delivers ready for unloading. So unloading will be done by whom? It will be done by the seller, and buyer is to handle the import clearance. So let me write over here. So if we are talking about the import clearance, that is to be done by the buyer in this scenario. So at a designated place, the goods will be delivered by the seller and risk will be transferred to the buyer thereon, right? So import clearance is to be done by the buyer only. The third one, it's very important, that is free on board. FOB value. We say to be free on board. So seller is going to load the goods on the vessel, right? On the vessel, the goods will be loaded by the seller. And further, when the goods are on board, after that, the risk is going to transfer to the buyer. And this is suitable only for the bulk cargo. So let me write over here. So this FOB is suitable for what? Suitable for bulk cargo only. Further, after that, the fourth one, it's about the FCA, that is free carrier. FCA is what? It is the free carrier, right? So seller delivers the goods to carrier nominated by the buyer. So carrier is to be nominated by the buyer, or agent which is nominated by the buyer. The seller will be delivering the goods to that particular agent, and seller is responsible for export clearance. For export clearance, who will be responsible? The seller is going to be responsible for export clearance and risk transfers at delivery to carrier. So when the delivery is made to the carrier, the risk transfers from the seller to buyer. The next one, that's the fifth one, it's about the free alongside ship. As the name suggests, what is going to be there? In case of FAS, like seller places the goods alongside the vessels and not going to onboard the goods. So when the goods are alongside the ship, the risk is transferred. Export clearance is to be done by seller. So export clearance is to be done by seller. See, when you're on the vessel or nearby vessel, it means the export clearance is to be done by seller. Otherwise, it is to be done by the buyer. Getting it? So let's say if the buyer is to pick from Ludhiana, right? No port is there hereby, no vessel is there. So it will be the duty of the buyer so as to get the export clearance. But let's say when the goods are on board or alongside the vessel, in that scenario, it's the seller's duty so as to get the export clearance. I'm not talking about the import clearance, about the export clearance we are talking about right now. Okay, and the next one, that's the sixth one, it's about the CFR, that is cost and freight. So seller is going to pay the freight. Risk transfers once the goods are loaded. So when once the goods are loaded, risk transfers, and there is no insurance obligation. There is no insurance obligation. So seller delivers the goods on the ship at a designated port and pays the cost and freight to bring the goods to the port and not responsible for insurance. The CAIF value, that is cost, insurance, freight. Now the seller delivers the goods on the ship at the named port and pays the cost, freight and insurance of the transport. That's to be paid by the seller in case of CIF value. Eighth one, it's about the CPT, that is carriage paid to. CPT, that is carriage paid to, seller pays the freight to named destination. So to a named place or named destination, the seller is going to pay the freight. Risk transfers when the goods handed over to the first carrier. Let's say the goods were to be basically carried till Madras, okay, at a named place. And after Madras, the responsibility will be with the buyer. The risk will be with the buyer. But in case of CPT also, insurance is not mandatory. Then it is CIF, that is carriage and insurance paid to. CIP value. So this is same as a CPT. But in this scenario, you are basically the seller is carrying the goods to the named destination, named place, but also responsible for the insurance. So we can say same as CPT plus insurance. That is to be done by the seller, by the seller. Okay. Further, it's about the DPU, that is delivered at place unloaded. Now, the seller is going to deliver the goods at the designated place also, and also to unload the goods, and also to unload the goods. So risk transfers after the unloading. After the unloading. So buyer takes care of any import clearances and taxes and duties. So this is just related to unloaded. The goods are to be basically carried to particular place and also to be unloaded there. Okay, and this is the only rule, this is the only rule which requires the seller to so as to unload the goods so as to complete the delivery. Only rule for that. That's the 10th rule we can say. And further, the last one, it's about the DDP. It's about the DDP, means delivered duty paid. So maximum obligation is on the seller. So seller bears a maximum obligation, maximum responsibility is there. Freight is to be paid, insurance if agreed, that is to be paid, import clearance is to be made, right? And also the duties and taxes are to be paid. So that is the main point related to DDP. That's a delivery duty paid. Everything is to be borne by the seller. So these are the 11 Incoterms. So what Incoterms are these? First one, it's about the EXW, that is X work, right? Further, FCA, that is a free carrier, and CPT, that is a carriage paid to, and CIP, that is cost carriage and insurance paid to, and for the DAP, that is delivered at place, and DPU, that is delivered at place unloaded only rule, which requires the unloading so as to complete the delivery, and DDEP, that is delivered duty paid, maximum responsibility is on the seller, maximum responsibility is on the seller, that is DDP. Further, it's about the free alongside ship, that is FAS, FOB, that is free on board, CFR, that is cost and freight, and further CIF, that is cost, insurance and freight. So these are the 11 Incoterms. These are the 11 Incoterms. I hope that you must have understood all the points related to it. Clear with it? Do confirm at the earliest if you have understood the part so far, so that we can proceed further. Do confirm at the earliest so that we can proceed further. And if you have understood that particular part, make sure to like this video and share this video. Do like this video and share this video among your friends, colleagues who are preparing for the CAIIB. Simply just write CAIIB and WhatsApp it to the number 83609 44207, and I'll be sharing all the details with you. So let's now move further. It's about the crystallization of foreign currency liability. Crystallization of the foreign currency liability. Now, what does this indicate? What does this indicate? A crystallization means what? That we need to convert the overdue or unpaid foreign currency. So if there was a unpaid liability in foreign currency and that was not paid, we have to crystallize it into domestic currency so that it may not worsen further. Because let's say the case that the foreign currency is priced at 89.12. 1 USD is equal to 89.12 INR, right? Now you know that this particular liability is overdue and it is to be paid, but it's not picked up and it's not paid. It's overdue. It's not paid, right? Now what will happen? You have to crystallize it. You have to crystallize it. Crystallize means what? Let's say a liability was to be paid in foreign currency. 50,000 USDs were paid. 50,000 USDs were paid. Now amount is to be paid in USD. Alright. So bank was to receive the amount particularly. Let's say bank was to receive this amount. But now this amount is not paid and this is now due. Overdue. And this is now overdue. Now how it will be resolved? How we are going to resolve this thing? We are to crystallize this value. We are to crystallize this value. Means we are to convert this exposure into INR. INR. Right? So that even if the currency rate is having volatility, it may increase or decrease now, right? So it will not be impacting you. It will not be impacting us, right? So liability that becomes that was to be paid in USD, now that becomes payable in INR. Now exchange rate fluctuation will basically, that risk is going to stop because exchange risk won't be there. And further, it becomes a funded exposure if it is unpaid. It becomes a funded exposure if it is unpaid. So issuing bank on receipt of the documents. So let's say when the issuing bank received the documents, how many days are with the issuing bank or the opening bank? The bank is having 5 banking days. It is having 5 banking days so as to pay off the so as to scrutinize the documents. And further, after that, if it's a complying presentation, it's an obligation so as to pay immediately. So either the reimbursement bank will be there or the issuing bank itself will be clearing the amount with the negotiating bank, right? So if the documents are drawn on site, then the payment is to be made automatically at the same time. And further, if it is on usage basis, then the payment is to be made after the credit period, but that particular payment is to be paid made because it's an obligation. It's a undertaking, irrevocable undertaking given by the issuing bank. That's if a complying presentation is made, then the payment is to be made. Now if the documents are drawn at site, documents are drawn in sight and in terms with the extent of FEDI rules as per the Foreign Exchange Dealers Association of India rules guidelines. Now, in that scenario, it is now to be crystallized as per the bank's own discretion. Let's say if it is due and applicant has not made the payment. Now, the payment has been made by the issuing bank, but the payment is not cleared by the applicant or by the importer to the issuing bank. In that scenario, the bank at its own discretion as per their board of directors policies, they will be crystallizing the liability. They will be crystallizing the liability. And in case if the bill is not retired or paid by the importer within the period, so in case if it is not retired or is not paid within that particular period, it's the issuing bank who will be deciding when it is to be crystallized, and they will be having the authority so as to crystallize this foreign currency amount into the Indian rupee, into the Indian rupee. Clear with it, right? And further after that, it's about the evidence of import by the importer. Now, when anything is imported in India, there must be an evidence that is to be submitted to the authorized dealers bank. There must be an there must be an evidence related to it that the import has been made. So under the FEMA provisions and RBI directions actually, which are applicable to the authorized dealer category 1 bank. So whenever an import is made and the foreign exchange is remitted for the import purposes, the importer is to submit the documents for the evidence of the actual import purposes. The main purpose is what? That we want to ensure that whatsoever the import has been made and the remittance has been made for that particular case, that is genuine one, and so as to prevent the money laundering, and also so as to ensure the compliance with the trade and the foreign exchange regulations. That's very much required. So it's a duty of the importer. It's the duty of the importer so as to submit a valid document like bill of entry. That's a primary evidence. Bill of entry is the primary evidence, right? So it's basically generated by the custom authorities. It indicates the clearance of goods in India, that your goods have come in India. And further, it must be electronically verified through ICE gate. ICE gate is basically customs software, right? And bill of entry should be cleared, should be verified through the ICE gate, through the ICE gate. And for the imports below rupees 5 lakh, below rupees 5 lakh, as this is a tolerance limit, simplified evidence can be accepted subject to the bank's policy. But if the import is beyond rupees 5 lakh or up above rupees 5 lakh, in that scenario, the bill of entry must be there, which must be verified through the ICE gate system. And this is mandatory for the imports which are 5 lakh rupees or above rupees 5 lakh, or above rupees 5 lakh. And let's say the case that if the authorized dealers are not receiving the, are not able to receive the bill of entry within the 6 months of the payment. Let's say the payment has been made to the exporter, but the authorized dealer is not able to get the bill of entry for the 6 months. So there should be a follow-up that must be given with the importer so as to submit the bill of entry. And let's say if it is not submitted for the next 3 months, then it should be reported in the BEF statement. That is bill of entry fail statement. That is BEF statement. It should be reported in that scenario. And further, this particular statement is to be submitted within 15 days from the close of the half year to which it relates. This BEF statement, and that is to be submitted on half yearly basis to the Reserve Bank of India. So this entry is to be submitted within a period of maximum of 6 months. And further after that, the follow-up is to be done. We can simply be saying that the follow-up is to be done. And let's say if it is not submitted, then further we should be waiting for another 3 months. Then after that, it is to be reported in BEF statement. It is to be reported in the BEF statement. Clear with it? Right? See, in exceptional cases, we can be going for the chartered accountant certificate. Chartered accountant certificate. Like if the import is not subjected to the custom clearances, like in case of the software download, or let's say bill of entry is not generated, in that scenario, we can be going for the chartered accountant certificate. CA certificate can be taken care with, right? The next one, it's about the standby letter of credit. The next topic that we are going to cover, it's the standby letter of credit. Now I told you that in some countries bank guarantee cannot be issued, like in case of the USA. So there the substitute is standby letter of credit. The substitute is standby letter of credit. We say it to be SBLC. That is standby letter of credit. So it's a substitute for the bank guarantee, right? So it is an irrevocable undertaking which is issued by the bank so as to pay the beneficiary when the complying demand will be made. When the complying demand will be made. So it functions as a default payment mechanism, right? It's not a primary payment instrument. It's not the primary payment instrument. So this type of letter of credit is opened by the banks in the countries where there is restriction in issuance of the guarantees. So it provides a substitute for the performance or the financial guarantee. So it's a suitable substitute for the performance and the financial guarantees. Clear with it? So SBLC serves as a backup and secondary payment mechanism. It serves as a backup and the secondary payment mechanism, right? And further, when default will be made on the part of the buyer or applicant, then the payment is to be made by the issuing bank to the beneficiary. So the beneficiary will be submitting the claim that the performance has not been met, and further the payment will be made by the applicant's bank, by the issuing bank or the opening bank to the beneficiary. Clear? And this is a payment of last resort. This is used as a payment of the last resort. So that is a SBLC or SLOC, that is standby letter of credit. Then it is a commercial standby letter of credit for the import of goods. Now the banks actually have been permitted in India also. In India, the permission has also been given by the Reserve Bank of India so as to issue the standby letter of credit so as toward the import of goods in India. So if you have to import the goods in India, standby letter of credit can be issued. So there will be no underlying transaction as such. There will be no underlying transaction. It will be just a guarantee that is basically issued in the form of the standby letter of credit. So standby letter of credit is going to cover the import of goods that are susceptible to certain attendant risks. Let's say, because definitely there is not going to be the evidence of shipment. There is not going to be the evidence of shipment, and if the goods are not involved, definitely the insurance cover is not there. So importer should be advised and explain the risk factors which are involved in case of the standby letter of credit. So that should be taken care of particularly. Although it has been allowed by the Reserve Bank of India, right? But definitely there are so many risks involved in that because there is no actual trade transaction. And ultimately, when there is no such trade transaction, definitely there will be no evidence of shipment. And further, no insurance cover is there. So banks should be vigilant about it. And further, if the standby letter of credit is to be invoked, there should be proper evidence in that particular regard. Supporting documents must be there. Supporting documents must be there because a claim is to be submitted by the beneficiary. The beneficiary is going to submit the claims that's going to invoke the particular letter of credit. So that should be particularly be showcased, like supporting documents must be there. And let's say case that the beneficiary of the credit is to give a declaration related to it. Declaration related to it that if the claim is made on account of the failure of the importer, so the contractual obligations are to be fulfilled. Undertaking is to be given. So the documents must be presented like the copy of invoice, non-negotiable set of documents, and a copy of inspection certificate, right, as per the underlying contract. So these are the important documents. Those are to be presented along with the SBLC. Clear with it? Now, after that, we are going to cover the case study questions for the letter of credit. For the letter of credit, we are going to cover the case study questions. So here is a list of the different questions that we are going to cover. So make sure to watch this video till end. We are going to cover almost 5 case studies. One by one, we are going to cover the 5 case studies. So if you want to get the complete set of the case studies, more than 100 case studies are there. Previous year questions are there, mock tests are there, mega tests are there, PDF notes are there, which are printable and downloadable. So for that particular scenario, just simply do download the application which is available at this particular link, iibf.info/app. Do download the application. And if you are iOS user, it will be asking you for the ORG code, which is GEGKT. Or simply you can be WhatsApping to the number 83609 44207, and I'll be sharing all the details with you. And I'll be sharing all the details with you. Clear with it? So let's start the case studies now. The first case study, it says Messrs Exports Private Limited received a letter of credit for export of goods for the export of goods amount of rupees 50 lakh approximately. The company manufactured the goods and made the shipment and presented the documents for negotiation to the negotiating bank for the total invoice of 52 lakh 35,600 rupees. The negotiating bank refused to negotiate the document as the amount exceeded the amount of the letter of credit. What is the position? What is the position of the exporter under the given situation? So we need to tell about it. We need to answer about this particular fact. Clear? So Messrs Export Private Limited basically presented the document, received a letter of credit, means that's the exporter we are talking about. So that's the exporter we are talking about. And further, they received the letter of credit which specifically indicates rupees 50 lakh approximately, right? And the letter of credit, the documents are drawn amounting 52 lakh 35,600. So what is the excess amount which is drawn? It is 2 lakh 35,600. This is the excess amount which is drawn. This is the excess amount which is drawn, right? And further, negotiating bank has refused to negotiate the documents because amount exceeding the letter of credit value. Now, is it allowed or not? First of all, do answer in yes or no. Do answer in yes or no, so that and you should be participating. Definitely, you should be participating and you should be answering the questions. The more you participate, more you will be learning. So let me tell you. So definitely the UCP rules are applicable. UCP 600 rules are applicable. So if UCP rules are applicable, means the articles are applicable. And I told you about the article number 18. I told you clearly about the article number 18. So we have covered already the different articles about it. And if you basically memorize the article number 18, it was all about what? It was about the commercial invoice. It was about the commercial invoice, right? And also, I told you about the article number 30. So article 18 was related to what? It was related to the commercial invoice. Let me write like what should be the content of the invoice and everything. So, and further, we also talked about the article number 30, which deals about the tolerance in credit amount. Article 30, which dealt with the tolerance limits. And under the tolerance limit, I told you about two limits. Like if the words about or approximate are used, about or approximate are used, so the tolerance limit will be plus minus 10%. The tolerance limit will be plus minus 10%. Now in this scenario, the LC is drawn for 50 lakh rupees approximate, right? Means plus minus 10% if we do consider, it will be ranging from 45 lakh rupees till 55 lakh rupees. And it will be considered valid if it is ranging between these amounts. Now the documents which have been drawn, that's amounting 52 lakh 35,600. So it's a valid amount which is mentioned. And this is as per which particular article? This is as per the article number 30th. Clear with it? Do confirm at the earliest if you are able to understand these points. Do confirm at the earliest if you are able to understand these particular points. Now let's move toward the next question, next case study. Messrs. Export Private Limited received letter of credit for export of certain goods letter of credit, and it does not state the quantity in terms of the stipulated number of packing units or individual items. The exporter manufactured the goods and presented the documents for negotiation, which have been initiated by the negotiating bank. However, the opening bank refused to honor the documents on fact that there is a variation of around of 3% in the quantity of goods supplied. The negotiator banks demands the return of money from the exporter. What will be the exporter's position in this case? So here is a scenario that the letter of credit was presented to the exporter, and further it is clearly mentioned that the letter of credit does not state the quantity in terms of stipulated number of packing units or individual items. It is not stipulating the quantity which is basically required to be shipped. An exporter has made the shipment. Negotiating bank has negotiated the documents, and the documents have now been presented to the importers bank, that is to the issuing bank. And issuing bank basically refused further. Opening bank refused further to the fact there is variation of around 3% in the quantity of the goods. Now the negotiator bank demands the return. Negotiating bank is asking for return of the money from the exporter. So what will be the position of the exporter? Again, the relevant article is article number 30. That's about the tolerance limits. Article number 30. One, it was about the amount, which is if the amount is approximate or about, then the tolerance is plus minus 10%. And the another one, it's about the number of units. And the article 30 clearly says if the LC does not specify the quantity in terms of the stipulated number of the packing units or the individual items, in that scenario, for the quantity purposes, the tolerance is plus minus 5%. The tolerance allowed is plus minus 5%. So is the issuing bank justified? Here the variance is just 3%. Here the variance is just 3%, whereas the variance allowed is up to plus minus 5%. So is the fact justified by the opening bank that they are going to say that we are not going to comply with the letter of credit? No, they are not justified. They are not justified, right? So because the shipment is in permissible limit, so this as per the article number 30. So what is the position of the negotiating bank? Because the question can be asked from multiple angles. So if we talk about the position of the negotiating bank, what would be that? So if the negotiation is made with recourse, because that can be the scenario, if it is with recourse, or it may be without recourse, or it may be without recourse. Both the cases may be there. Now, if the negotiation was with recourse, negotiating bank can legally recover from the exporter. Legally, can you be legally recovering from the exporter? No, because it is not required at all. The letter of credit bills have been drawn generally, and those are fair enough, right? But when we're talking about the with recourse and without recourse, what does it indicate? That if the documents have not been, let's say, negotiated by the opening bank, and if these are with recourse, then definitely the negotiating bank can recover the amount from exporter, right? And in case of without recourse, the amount can't be recovered. In that scenario, the amount can be recovered from the exporter. Clear with it? Now, let's move toward the next case study. It's the third one now. It says International Bank, New Delhi, received a letter of credit issued by a bank in USA in favor of Messrs. ABC Private Limited, a customer of the International Bank. The negotiation is restricted to the international bank. On the date of receipt of the letter of credit, rights took place in the locality where the branch of the bank is located. As a result of the LC could not be advised to the bank to the exporter immediately. Later, when the situation became the normal, the exporter advised a letter of credit to the bank, but the time expiry date negotiating the documents has expired. The exporter insisted on negotiation of the documents by the international bank as the delay is not the part of the exporter but on the part of the international bank. So what is the position of the international bank vis-a-vis exporter in the given situation? So we are to tell that what is going to be the position about the international bank and about the exporter. We are to answer on that. We are to tell about that if it is valid or not. Who is right? Exporter is right or the international bank is right? So fact is what? LC is issued by the US bank. Fact is, let's say here the USA bank we are talking about, which basically issued the letter of credit. So issuing bank here it is the US bank, right? And negotiation is restricted to the international bank, New Delhi. Negotiation is restricted to the international bank. There is a bank that is an international bank, and this is going to be the negotiating bank, right? And further, on the date of receipt, this is clearly told na, that on the date of receipt of the letter of credit, rights took place in the locality where the branch of the bank is located. As a result of this, LC could not be advised to the bank to the exporter immediately. LC could not be advised to the exporter immediately because the rights were there. And by the time exporter presented the documents, LC expiry date has already passed. So when the documents were presented by the exporter, presented to whom? Presented to the international bank. Now the expiry has already passed. Letter of credit expiry has already passed. Now in how many days the letter of credit is to be presented? So it is 21 days or let before the letter of credit expiry, whichever is earlier. Whichever is earlier, the documents are to be presented. But now the letter of credit has already passed. Exporter basically insists the negotiating bank that the claiming delay was bank's fault and it's not default. So what will be the rule over here? So what will be the rule over here? Now we discussed about one particular article, which is the article number 36. It was a article 36, which is a force majeure. It was a force majeure. Now, banks actually do not assume any liability or any responsibility if the interruption of business was due to rights, due to war, due to civil commotion, due to acts beyond the control. Clear with it? So, as per that, whatsoever the international bank is saying, that's absolutely right. It's not the responsibility of the bank so as to honor or negotiate after the expiry, and no extension is automatic. So extension is not automatic. So LC expiry is absolute in this scenario. And particular expired LC cannot be extended automatically. Force majeure basically protects the bank from its liability. And definitely the delays due to rights, they do basically qualify for the force majeure. They do qualify for the force majeure. Right? Clear with this? Now let's move further about the next case study. About the next case study. So Messrs ABC Private Limited has received the letter of credit in their favor for export of certain goods to Canada. Kindly try to understand the case study because these are very important concepts. All right. So what actually happened, that the Messrs ABC Private Limited has received the letter of credit in their favor. So it means it's about Messrs ABC is the exporter, and further for the export of certain goods to Canada, the date of expiry of the letter of credit is on or about 31st December 2020. The expiry date is on or about 31st of December 2020. And since the process involved in manufacturing of goods was bit longer, the exporter could present the documents for negotiation on 3rd of January. So the documents were presented to the negotiating bank on 3rd of January 2021 and after the 31st December 2020, because the expiry was 31st of December 2020, on or about 2020, 31st December 2020. So the documents were not negotiated by the negotiating bank refused, all right, to which the exporter objected. Opinion of the exporter that there is no deficiency. The exporter said that there is no deficiency in the documents, and in the opinion of the bank, the documents have been presented, not presented under the negotiation in time. So what is the position of the bank and the exporter? So what is the position of the bank and the exporter in this scenario? Now see, the letter of credit expiry is mentioned to be 31st of December 2020, but it's not just 31st of December. It is clearly mentioned it is on and about 31st December 2020. On or about. When we're talking with the on or about, when we are talking the on or about, the legal things are also to be looked into. Those are also to be looked into. And that's about what? On or about. And further, that particularly adds another 5 days for the presentation. Otherwise, I told you about the article number 14. I told you about the article number 14, which says that the presentation period is 21 days. 21 days or before the expiry of letter of credit. It is either 21 days or before the expiry of the letter of credit, the presentation is to be made. The presentation is to be made in that scenario. Clear with it? Kindly confirm if you have understood this particular part. Because these are very much required. Right? And also we learned about that the issuing bank will be having 5 banking days. So as to check if the particular compliance is genuine one or not. If the compliance is genuine one or not. That we also covered. So when the letter of credit says, so when the letter of credit says that that the letter of credit is going to expire on or about, when we are saying that the letter of credit is saying that it's going to expire on or about, or similar interpretation is there, in that scenario another 5 calendar days would be available, and that is as per the article number 3. That's the about the interpretations. So article number 3 clearly says if on or about or similar wording is used, if on or about or similar wording is used, right? In that scenario, another 5 calendar days, not the banking days, kindly note, another 5 calendar days would be awarded. Now, the actual expiry date is on 31st of December 2020, but that won't be the expiry date. It will be either 5 days ahead or before 5 days. So it will either is basically up to 5th of the January, it is valid. 5th of January 2021, it is valid enough. As per the expression is related to on or about. as per the expression is related to the on or about, right? So it is valid one. So letter of credit is valid one. So the documents which have been presented even after the date of expiry, but as per the law, it's basically valid one. Why valid one? Because it is clearly said on and about in this case. Okay. So that will be all related to this particular video and concepts, and we'll be covering the rest two case studies in the next video. Make sure to watch that particular video, and further, if you have not subscribed to the channel, do subscribe at the earliest. And further, you can be downloading the application which is available at the above link iibf.info/app, and you can simply be WhatsApping, writing CAIIB to the number 8360944207, and I'll be sharing all the details. Thank you so much, and see you again in the next video.